So your full name and date of birth?
Jason Powell Valencia.
All right, thank you, sir. We're here for a new case out of Superior Court. The charges are three counts of misconduct involving weapons. Those are Class 4 felonies, 1 count of armed robbery with a weapon, a Class 2 felony, 1 count of aggravated robbery, a Class 3 felony, and 2 counts of theft, Class 6 felonies. These all have an offense date of yesterday, September 11. In this matter, the Public Defender's Office has been appointed to represent you. Your court dates at this time are a status conference September 18 and a preliminary hearing September 20, both at 8:30. And those are going to be at the Superior Court located in downtown Phoenix. In this matter, I did receive a written recommendation from the state here as well, requesting a $150,000 cash-only appearance bond. Based on the nature of the offense, the fact that it does involve the use of firearms, and it is a violent offense, and I do believe you are a danger to the community as a result of these allegations, I am going to be setting a significant bond. You do have a $100,000 secured appearance bond with orders that you are not to have any contact with any victim, complainant, witness. You are not to possess any weapons while you're on release in this matter. You are going to receive this information here in just a moment, but do you have any questions regarding it?
No.
All right, go and step over to your left. You can go and have a seat. All right, this is not Mr. Carrillo. I'm assuming you are Mr. Chisholm instead. All right, sir, go and state your full name and date of birth.
Dante Aaron Chisholm.
All right, sir, you are here for 3 separate cases. All 3 of these are going to be probation violation warrants that were issued. In each of your probation matters, there's been a petition to revoke filed. It alleges a violation of terms 3, 5, and 15 of your probation terms. The Public Defender's Office has been appointed to represent you in this matter. You currently have a revocation arraignment hearing set on September 19 at 8:30. That'll be at the Superior Court located in downtown Phoenix. In this matter, the bond in each of those warrants has been affirmed. The first one is a $500 secured appearance bond. The next 2 are both $1,000 secured appearance bonds for a total of $2,500 for all 3 matters. These are secured. You are able to work with a bail bonding company in order to post them, but if you do post bond and you are released from custody in these cases, you are still on IPS for that level of supervision. You do still need to abide by all the terms that apply to IPS supervision, as well as contact your probation officer within 24 hours of your release from any facility. You'll get that information here in just a moment, but do you have any questions regarding it?
Oh, what's a revoke mean?
That means, well, I mean, you've already gone through this process. You've already been reinstated 3 times in at least one of these matters. So it's the same process you've already been through. They filed a petition to revoke back then as well. It looks like you were reinstated at that time. They've now filed another petition to revoke. What they're saying is they believe that you should be revoked to DOC. As far as whether you get revoked and end up getting prison time in these matters, that's up to the probation judge, and these matters are going to be headed there next to be heard.
Okay.
Okay? All right, any other questions?
No.
All right, go and step over. All right, are we ready with Mr. Lopez? I'm sorry, we already did Mr. Lopez. Are we ready with Mr. Espinoza?
Oh, we are, Your Honor. Thank you.
Right.
I felt like you were looking at me, but
Let's go ahead and step up. And yes. Mr. Espinoza, if you could state your full name and your date of birth.
Edgar Espinoza.
Thank you. And if we could do appearances from both counsel, we're going to start with the state.
Captain Pollock appearing on behalf of the state, Your Honor.
Thank you.
Melissa Ball for Mr. Espinoza, Your Honor, who is standing to my left.
All right, thank you. And Ms. Bauer, I did receive a notice of appearance. It looks like this is a limited notice at this point. Is this just for today?
At this point, yes, Your Honor.
Okay. All right. So, Mr. Espinoza, what I'm going to do is I am still appointing counsel to represent you in this matter. It's going to be through the Public Defender's Office. Obviously, if you continue to retain your own attorney, they would need to file a further notice of appearance in order to do so. So you can continue to do that. I'm just going to be appointing counsel out of an abundance of caution to ensure that you do at least have some representation just in case. Okay? You are here for a new case out of Superior Court. It is alleging 1 count of criminal damage. That is a Class 6 felony with the offense date of September 11, so yesterday. Before I get to the court dates here as well as release conditions, let me go ahead and Ms. Bauer, ask you first. I'll let you know, I did find probable cause based on the information submitted to the court at this time. There was really minimal information submitted regarding this case, but I did find at least enough for probable cause on the charge submitted. But if you want to address probable cause, I'm happy to do that right now.
No, Your Honor, we're just interested in release conditions.
All right, thank you. And any position on this from the state?
Your Honor, I agree that the condition, or that the Form 4 is pretty limited in the facts. It doesn't indicate what relation, if any, the victim is to the defendant. Although I suspect it may be either a family member or a girlfriend or something like that. And so for that reason, I'm going to ask for the defendant to be released to pretrial services with electronic monitoring in order not to contact the victim, whether that's initiated by the victim. You still can't have contact. If the victim tries to put it in, you should refuse that contact just to ensure that that victim is safe. Thank you.
All right, thank you. All right, go ahead.
Your Honor, we would ask for OR I'm sorry. Oh, I didn't know if I was talking.
Go ahead.
We would ask for OR release, Your Honor. Mr. Espinoza has no criminal history. He is not a flight risk. His job here, his kids are here. His home, which is where he was arrested, is here. Everything is here. Obviously, they have retained private counsel. I expect I will continue on the case. It's just some paperwork that needs to be executed. With that being said, it is limited. It's an allegation that he broke a phone. I don't think that's sufficient to warrant ankle monitor and him be released to pretrial services, Your Honor. So I would ask for OR, that no contact is understandable and that could stay in place. I would ask that he be allowed to return to that home with the understanding that if she is still there, he obviously would not stay and he would go find somewhere else to be. But we do have a suspicion that she's no longer there and she will likely be with family at this point.
All right. Do you have a way of figuring out whether the victim is still residing at the home without actually going back there in person to make that determination? Because you're not going to be allowed to do that.
I can call somebody.
You could talk to your family.
But el con el que vivo, I can call him.
Yeah, he said there's actually a roommate there that he could ask.
Okay. All right. So here's what we're going to do. I did take a look at your criminal history. I'm aware that you don't have any prior convictions. I don't see any prior arrests or anything for any other violent offenses. And again, I am certainly going off of some pretty limited information, although I can make some assumptions regarding the relationship involved here, but clearly that was not included in the Form 4 in this matter. Based on the review of your history, I am going to be releasing you on your own recognizance. It is going to be your promise to appear at all future court dates. You do have orders here that you are not to have any contact with the victim or any complainant or witness in this matter. There is an order protection order against harassment filed. You must obey the terms of that order. I am going to echo what the state said with respect to the no victim contact. Even if she contacts you, assuming it's a she, even if she contacts you, that does not mean you can have any contact with her. The only one that's going to be in trouble for that contact is you, okay? Because you're the one with the order, all right? And I'll just warn you that a violation of a no victim contact order and a criminal release order, which is what you have at this point, that could constitute aggravated harassment, and that's a Class 6 felony, okay? If you come in here on a new felony offense while being on felony release in another matter, you would be non-bondable at that point. You would not be eligible for release, okay? All right. I did not put that you cannot return to the home, but I do have in here that you cannot reside with any alleged victim. Even if it's your home, even if you're the one that rents or owns the residence, you cannot reside with the alleged victim. So what that means is if the alleged victim is still residing at your home, you cannot return there, okay? If the alleged victim has vacated the home and is no longer residing there, you can return there, all right? But this isn't a move her out, force her out. If she was residing there, you can't force her out, okay? You just can't live there. You'd have to find an alternate residence. Okay? And if that does happen, if she is still residing there, you do have to find an alternate residence. You can only go back there in person in order to obtain any personal items using a civil standby. That's done by contacting local law enforcement in order to do that. Okay? All right. Anything else that we need to address from either counsel?
Nothing further, Your Honor. Thank you.
All right. Thank you.
So you can do the release later and then give me
Good morning.
We saw.
Or good afternoon.
All right, sir, your full name and date of birth?
Joe Carrillo, 2/20/1981.
All right, so you are here for a new case out of Superior Court. The charges are 1 count of possession of narcotic drugs, a Class 4 felony, 1 count of aggravated assault involving an officer, a Class 5 felony, 1 count of felony, 1 count of resisting arrest, a Class 6 felony. There is also a charge for possession of dangerous drugs. That is the only charge that I did not find probable cause on here today. Doesn't necessarily mean it's going away, but I was not provided with enough information on just the one
What's
count.
going on over here?
In this matter, the Public Defender's Office has been appointed to represent you. You have a status conference set on September 18 and a preliminary hearing September 20, both at 8:30, and those are going to be at the Superior Court in downtown Phoenix.
Yes, ma'am.
In this case, I did review your prior history, which includes a number of prior felony convictions,
Yes, it does.
including a prior aggravated assault. Looks like you just had a 6-year term in the Department of Corrections for that violent offense.
I finished.
So in this matter,
Oh,
you have a bond. That's a $7,500 secured appearance bond. You're also going to be ordered not to have any contact with any alleged victim, complainant, or witness in this matter.
Yes.
We'll get you all that information in your paperwork in a moment, but do you have any questions regarding it?
Would you please consider release for appear on my own recognizance, ma'am? I'm also provided for my daughter and my wife. I just had a kid, and I work for Great Pro, and I don't do it. This was a big mistake, and I don't know. I'm not on parole. I'm not on. You can see that I haven't done anything in the last 6 years. I haven't gotten in trouble or nothing. I know it's in prison stuff, but everything holds up, you know, like that. But
Yeah, I'm not going to consider anything lower with your history. In fact, I considered something higher, okay?
Yeah.
So I'll let you know the only change I would make at this point would be to increase your bond, not to lower it, and certainly not to get rid of it. So
Okay. So
I'm sorry to hear
75
about what you've done to your family members and possibly your employment as a result of your actions here today, but it's not going to change your release conditions.
Okay, so
All right?
just a bond. That's it.
You do have a bond.
Okay.
All right? If you want to go and step over, you can go and pick up that paperwork. You can have a seat. All your information will be included in there.
Okay. Thank you.
All right, Mr. Hampton, and then we've got Daisy Padilla up after that. Hi, Mr. Hampton, go and state your full name and date of birth.
For Sanchez Hampton.
So you are here for a new case out of Superior Court. It is alleging one count of child or vulnerable adult abuse. That's a Class 4 felony with the offense date of September 10. The Public Defender's Office has been appointed to represent you in this matter. You have a status conference set on September 18 with that preliminary hearing September 20, both at 8:30, and that's going to be at the Superior Court located in downtown Phoenix. You'll get the address in your paperwork. Based on the very serious nature of the charge that you're here for, the danger I believe you pose to the victim in this matter, I am going to be setting a bond in your case. That's a $25,000 cash-only appearance bond. If you do post that bond and you are released from custody, it would be subject to the supervision of pretrial services. You'd also have electronic monitoring set prior to your release, and that's being put in place because you're going to have orders here that you are not to return to the scene of the offense, you are not to have any contact with any alleged victim, complainant, or witness in this matter, which means you cannot have any contact with the minor child involved in this case, and that's whether or not they've been removed by DCS. I don't know what involvement they've had at this point. If you do need to return to the residence because you have personal items there that you require, you can only do that using a civil standby. That's done by contacting local law enforcement in order to pick it up. And then I'll also just warn you as well that a violation of a no victim contact order and a criminal release order, that could constitute aggravated harassment, and that is a Class 6 felony. If you come in on a new felony offense while being on felony release, you would be non-bondable at that point. Any questions regarding any of that information?
Was the public defender supposed to be here with me, representing?
No, I
me?
just appointed the Public Defender's Office to represent you. You certainly have the right to retain an attorney on your own behalf who can be with you at any point during this process. But no, the Public Defender is not here in the courtroom.
And if I just got accepted to a job by the post office, would that reject my offer by me being here?
I'm sorry, I couldn't hear what you said.
I said by me getting an offer from the post office, the United States Postal Service, would that reject my offer from me being here?
I don't know what the Postal Service is going to do as a result of this matter. That's not anything I have any control over or any knowledge of.
I had an orientation to go to, so I was trying to see if I can get probation and check in with you guys.
Yeah, you're not going to be released if that's what you're asking. I'm not quite sure what you're inquiring about, but you do have a bond that you would have to post in order to be released in this matter.
Okay.
Okay? All right, any other questions?
No, ma'am.
All right, thank you, sir.